right, good afternoon, everyone.
Good afternoon, Judge.
I'm Judge Corey Mandacothan. We're here for the afternoon docket for first appearances. I will begin by going through our afternoon first appearance docket. That will be followed by the hearing docket. Just a reminder to everyone that everything that we say is being recorded and can be used against you at a later date. And so I do encourage you to speak with your attorneys before speaking on the record today. Mr. Romero, is there anyone at Maine that needs to be called out of turn?
Judge, I spoke with my colleague. If we could take two issues out of turn.
Okay.
First one is Mr. Jeremy Mack. He's on the 40-day docket. Okay. We're waiving his appearance. My understanding and speaking with my colleague, I believe Mr. Lender State did file charges.
Jeremy Mack. He's on page 2 of the felony docket.
Yes, the state has filed charge of carjacking.
Okay. All right. And in light of that, the motion will be denied, and he'll go before the division judge for arraignment.
And right. Judge, the second issue I wanted to bring up, I believe Mr. Matthew McMaglemore, he's on your misdemeanor second look. My understanding, he's in courtroom 6170, so if we can reset it for tomorrow.
Hopefully.
Okay, those are second looks. I'm sorry?
No, I'm saying hopefully this matter will resolve itself in...
Okay. All right, so he has 2 cases on the misdemeanor docket, so those will be reset to tomorrow.
Thank you.
Thank you. Okay, so I do have Mr. Plant here on a couple of the MO cases, so if they are present, then I will take them. The first one is on page 1, Michael Tueros.
No problem.
Thank you.
When I called for him, I was informed that he was in the process of self-bonding.
Oh, okay. Well, I guess if he's bonding, you're showing that he bonded? Okay.
Thank you, Deputy.
All right. Well, then, thank you very much, Deputy.
You're
All right.
welcome.
For the record, I find probable cause, and that will take care of that one. Okay. Excellent. On page 2, Amir Redwan. All right. Thank you. For the record, I find probable cause. And Alvin Dunbar.
He's approaching.
Thank you.
There's your attorney, Mr. Plant.
All right. Good morning, Mr. Dunbar, or excuse me, good afternoon.
How you doing?
I am well. Mr. Dunbar, you are here today on a misdemeanor capias. This is a municipal ordinance, alcoholic beverage violation. I find probable cause, and I do have your attorney, Mr. Plant, present in the courtroom with me.
Good afternoon, sir. Judge, his offer is adjudication time served
Okay.
on the alcohol beverage violation.
All right. So, Mr. Dunbar, do you want to resolve your case today?
Yes, ma'am.
All right. So the offer is an adjudication time served. Do you understand that?
Yes, ma'am.
Okay. Will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. And now you can go ahead and put your hand down. And Mr. Dunbar, do you understand everything we've discussed so far today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak to your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence as to this charge will be an adjudication time served. Good luck to you, Mr. Dunbar.
Good luck,
All
sir.
right, ma'am.
Thank you, Judge. That's it.
All right,
Have a good
thank
day.
you, Mr. Plant. You got off easy today. All right, so now I'll go back to our first appearance docket. The first here that I have is Joseph Onley.
He's here, present Judge at Maine. He's approaching. Come on up, sir.
Thank you. Good afternoon, Mr. Onley.
Good afternoon.
Mr. Onley, you're before the court this afternoon on an out-of-state felony hold. This is out of the state of Mississippi. I find probable cause, and Mr. Onley, this has a no bond hold on it. Since it's an out-of-state hold, that means you'll be going before the extradition judge, likely on Thursday, so that you can discuss how this matter is going to be handled.
Judge, the only question we have is I did inform Mr. Onley he's going to extradition court.
Yes.
I believe that's in front of Judge Malika. He just wants his family be there. What courtroom number is it so I could tell him?
Do we know what courtroom is Judge Malika is? 5150? 5160. 5160. On the
Thank you,
fifth
Judge.
floor. Thank you. Okay, next is Craig Mitchell Fizel.
He's approaching, Judge. Me?
Thank you. Good afternoon, Mr. Mitchell.
Good afternoon.
Mr. Mitchell, you are before the court this afternoon on an ad charge. This is a charge for criminal mischief, $200 under $1,000. I find probable cause, and I will hear from the parties if they wish to be heard.
Judge, as being Mr. Mitchell, my understanding, Mr. Mitchell does not have a place to reside. He financially can't afford to post his bond. What I was going to be asking the court to consider is standard pretrial. Now, I do understand he was here, I believe, February 1st. He appeared to magistrates for a battery in which the magistrate judge allowed him to be released on non-monetary condition, but I believe with an Elmo. Obviously, since he doesn't have a place to reside, he's going to be here, so he's asking to be released on standard pretrial, Judge.
Your Honor, that doesn't really make a lot of sense. If he's not gonna get out, then he's not gonna get gain time if he's ROR to pretrial on count 2.
Agree with that? Okay, based on the circumstances, and, you know, especially in light of what Mr. Linders just said, it wouldn't make sense for him to be ROR'd on this, because if he's not going to be released, then he's not going to be getting time served on this charge. So if he's going to be remaining in custody for the other charge, then it would make more sense to leave the bond in place on this count.
The only other thing I'd be requesting, Your Honor, is no victim contact with his grandmother.
All right, any other information I need to be advised of, Mr. Romero?
Nothing else, Judge.
Okay, so in light of the circumstances, I'm gonna leave the standard bond in place. Well, Mr. Mitchell's walking away, but he needs to understand there's gonna be a no victim contact order in this case as well.
Yes, Judge.
Thank you. Kelvin Gilbert,
Mr. Gilbert, come on up, please. He's here at Maine.
thank you. Good afternoon, Mr. Gilbert. Mr. Gilbert, you are before the court on 4 misdemeanor capiases. These relate to charges for battery, reckless driving, leaving the scene of an accident, and leaving the scene of an accident. I find probable cause. I do see that count 1, which is the battery charge, is the only one that has a bond. The others are set at ROR, and he has a status hearing in front of his division judge tomorrow morning. So in light of that, is there anything else that the parties wish to be heard on?
Not at this time, Judge.
Okay, all right, so that $250 bond will remain in place. Next will be Bo Littlejohn.
Mr. Littlejohn, come on up, please.
Judge, on behalf of Mr. Littlejohn, I'm going to ask the court to keep the convenience bond as set.
Okay, let me just read for the record. Mr. Littlejohn, you're before the court on 2 charges. Charge 1 is for driving while license suspended. 2 is for disobeying a stop sign that is not for magistrate. I do find probable cause. Mr. Mr. Miller's indicated that he wants to leave the bond in place. State, is there anything else that you wish to be heard on? Okay, all right, so in light of that, the $100 bond will remain in place on count 1. Next will be Mark Bonilla, or Bonilla,
He's approaching, Judge.
okay? Good afternoon, Mr. Bonilla.
Good afternoon, Your Honor.
You're before the court on 2 capiases. Count 1 is a misdemeanor capias that relates to a charge for battery. 2 is a traffic capias that relates to a charge for driving with a suspended driver's license. I find probable cause. I do see Mr. Bonilla is set to have a status hearing tomorrow morning before his division judge. Do the parties wish to be heard?
Not at this time, Judge.
All right. Thank you. Anthony James.
Judge, Mr. James, was it Conti? I'm going to waive his presence, and we are not going to make any arguments.
I'm right here.
Is it Conti?
Yes.
Okay.
I spoke with Mr. James
All
a little while ago. We're not going to make any arguments regarding proof evident presumption grade on this filed charge and say, we're going to reserve for a future date.
Okay.
And Your Honor, this
Well,
state,
Mr. James,
Yes,
one
ma'am.
moment. You're getting ahead of me. All right, just let me first start. For the record, you are here on an ad charge. This is a charge for burglary with assault or battery. I find probable cause, and I'm gonna hear from Mr. Linder now.
I provided the court and Mr. Miller, after we finished our morning docket with a supplemental report
Yes.
covering the allegations in this case. Based on that report, for first appearance purposes only, Your Honor, the state would be seeking a finding of proof evident or presumption grade, that Mr. James be held no bond at this time on this charge. Just so the court's aware, he's being held on 2 other counts, a separate burglary with the battery and a, I believe it's a strong arm robbery that his bond was previously revoked.
So he's being held no bond on the other 2?
Yes, Your Honor.
All right. For the purposes of today's hearing and based on the information that has been provided to me, the court is going to make a preliminary finding of proof evident presumption grade in order that Mr. James be held no bond on this charge as well. That is, of course, without prejudice for him to have a hearing before his division judge to address that
now what
matter.
what does that mean?
Mr. James, you're already being held no bond on 2 other counts. This
Yes,
one,
ma'am.
this additional count is going to be no bond as well, which means that you'll be going before your division judge soon so that your attorneys can address that matter with the division judge.
Okay, well, I didn't get no understanding on
Judge, Mr. James, you can talk about it with your attorney. The case is filed, and you guys will be able to discuss whether or not you're going to be able to get a bond going forward. It's just not going to happen today.
Okay, does that make
Okay.
sense?
Okay, the case been filed.
It's been filed, Mr. James.
Who's the
So,
victim?
Walgreens, as with all the other charges.
But you know what I'm saying, there's a victim on the battery and assault.
Mr. James, I'm going to let you discuss it with your attorney after today's hearing. I think that would be in your best interest to discuss it off the record with your attorney, all right? And you'll be seeing the
No, I really
division
want
judge
to know.
soon.
I want some information.
Okay, well, I'm giving you the information. This is for burglary. It occurred at a Walgreens on December 29th. You are being held no bond on this count in addition to the other 2 that you're already
To
being
the
held
other
no
two,
bond
I
on.
understand the other 2, but they said I just spoke to my attorney and she made me. I signed a public defender application.
Yes.
It gave me reasonable counsel, right?
Yes.
And she just said that there's no victim on that one that you guys got me on right now. I got the case number on my hand.
Okay, well, I'm not sure which case number that's for because I know you have a number of
For the case
charges
number,
right
the
now.
assault and battery.
Your Honor, if I may?
Yes, go ahead, Mr. Linder.
Mr. James is scheduled for arraignment tomorrow morning at 9 a.m. before Judge Weeks.
Yes.
At that time, he will be formally advised of the charges and advised of the information in this case, Your Honor.
So tomorrow morning I go to court. I thought I go to court on the 11th.
So, Mr. James, you're going to be seeing Judge Weeks tomorrow morning for your arraignment hearing, okay?
Okay.
All right. Thank you.
I still don't understand.
Next is Serge Larivo.
No problem.
Thank you.
Judge, we're prepared to waive Mr. Lervo. Oh, there he is.
Here we go. All right. Good afternoon, Mr. Larivo.
Good afternoon.
Mr. Larivo, you're here this afternoon on an ad charge. This is an immigration hold. I find probable cause. And Mr. Larivo, this immigration hold has a no bond hold on it, which means that you'll go before an immigration judge to address this matter further. Good luck to you. Okay, next will be Lionel Derrico.
Come on up, sir.
Thank you.
Good afternoon, Judge.
Good afternoon, Mr. Derrico. Mr. Derrico, you're before the court on 3 charges. Count 1 is for grand theft, greater than $750, less than $5,000. 2, possession of cannabis, 20 grams or less. 3, driving while license suspended, third or subsequent offense. I'll hear from the parties.
Your Honor, I can advise the court that Mr. Derrico was released from state prison August 5th, 2018. That was after he was sentenced to 5-year state prison as a habitual offender on a carjacking. I believe pretrial, that's the most recent serious prior I have, but I believe pretrial has notes about his additional history.
Where were those from? Mm-hmm. Miami-Dade.
Judge,
Yes.
as you heard, Mr. Derrico does have a record. He has a history. But my understanding, speaking with Mr. Derrico, and certainly Mr. Lender can correct me, when he was released, he told me he got released about August 2018. He hasn't been in trouble since. He lives in Pompano Beach with his grandmother. He's been there basically his whole life. He's 34 years old. At this time, Mr. Derrico is not working. He gets disability. His grandmother cannot afford to post his bond. So we're asking on these nonviolent offenses if he could be released on pretrial release.
Let me just confirm with pretrial, since they were giving me the list for the priors that were outside of Broward County, what was the most recent one? Or have there been any since August of 2018, if you're able to tell me that?
Yes, there was a municipal ordinance in Broward for possession of controlled substance last year.
Is that it? Okay.
Take it on, Pod.
Yes.
He apologizes, Judge. He said it was, I guess,
Cannabis ticket.
a cannabis ticket.
Okay.
Staying out of trouble from 2018 till now, when you were when someone's qualified as a habitual offender for a violent first-degree felony like carjacking, that's really not a mitigating argument. Considering he's not before the court on a municipal ordinance controlled substance or any kind of misdemeanor, it's another theft-related offense, a felony theft-related offense.
All right. For the record, I do find probable cause. At this time, I'm going to leave the standard bonds in place. There will also be an order of no victim contact. Mr. Derrico, I don't know if you know the alleged victim in this case or not, but just so that you know, no victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
All right, thank you.
Judge, in the alternative, I understand the court's ruling as far as not, Mr. Derrico is not a acceptable candidate for pretrial. At the very least, on the misdemeanor possession cannabis, would the court consider an ROR on that count alone?
All right, I'll give him the ROR on count 2. The other standard bonds will remain in place. Next will be Travis Hall.
It is approaching, Judge. Come on up, Mr. Hall.
Good afternoon, Mr. Hall.
How you doing?
I'm well. Mr. Hall, you are before the court this afternoon on 5 charges. Count 1 is for grand theft auto. 2, battery on an officer, firefighter, or EMT. Count 3, resisting an officer, obstructing with violence. 4 and 5 are each parole violations which have no bond holds. I will hear from the parties.
Your Honors, I'm requesting $1,000 bond on 2, $500 bond on 3, considering he has a no bond parole hold with the Department of Corrections.
Judge, that's reasonable, but I'm also gonna be requesting a photo order so we can photograph the injuries Mr. Hall sustained.
Judge, I'm just gonna argue to count one. I know that they were, I missed this in the first read, but, I noticed that they were staking out a stolen vehicle, and Mr. Hall was near this stolen vehicle, but I don't see what connects him to the stolen vehicle. And again, I may have just missed that part.
I believe in the first paragraph in the second page. Yeah, I mean, that's fine with me. We can come back. I suspect, I think the officer was a little careless, but I suspect that set of keys is connected to that car, but that's fine. We can come back tomorrow afternoon.
Okay. I do note that, based on, there's a lot of information provided in the probable cause affidavit, but there's nothing to say whether the set of keys that Mr. Hall was running with go to the vehicle that was allegedly stolen in this case. So what I will do is I'm going to find probable cause to all the counts except for count 1, and I'll give the state 24 hours to perfect count 1.
Thank you, Your Honor.
You're welcome. And the bond on, so we'll deal with count 1 tomorrow. The bond on counts 2 and 3 will be set at $1,000 and $500, and I will sign the photo order that was requested. On count 2 is 1,000, count 3 is 500, but we're gonna give them 24 hours to perfect count 1. Okay, next will be Adama Sirota.
He's here, present, Judge.
Thank you. Good morning, Mr. Sirota, or good afternoon, excuse me. Mr. Sirota, you're here on 2 charges. Count 1 is for disorderly intoxication in a public place. 2 is for a felony probation violation, which has a no bond hold. I find probable cause. I do see Mr. Sirota has a hearing before his division judge on the VOP tomorrow morning. In light of that, do the parties wish to be heard on count 1?
Judge, I actually would ask the court to reconsider finding a probable cause in this case. He's charged with disorderly intoxication. The probable cause in this case is conclusory. There's no facts to support either disorderly or intoxication. Nothing about slurred speech, no bloodshot eyes, etc. There certainly was no blood test or breath test taken. And although it says there was a disturbance, it doesn't say what the disturbance was, who was disturbed, how they were disturbed. Everything in here is conclusory. There's no facts to support it. I would argue that there's no probable cause for count 1. And because there's no probable cause for count 1, there's also no probable cause for count 2. That's a 948 hold. There is no separate violation of probation. I would ask that the court find no probable cause and release him on his own recognizance on both of these counts.
Your Honor, it does mention a physical disturbance, and I believe that is satisfactory.
Doesn't connect him. He's not connected with the physical disturbance. It's just nothing. It's all conclusory.
It says he was involved in the disturbance, so it does connect him to the physical disturbance. And I would direct the court's attention to above the affidavit section where it says indication of, and the officer did check off indication of alcohol influence. And it would appear, and there's no reason to not believe based on the affidavit, that the officer had contact He is the arresting officer. He wrote the report that he had contact with Mr. Sirota and had an opportunity to observe him. Actually, he says, upon arrival, I made contact.
All right. Well, I do believe that Mr. Miller makes a very good point. Obviously, we have a much lower threshold when it comes to probable cause findings here in first appearances. So based on the information, the probable cause affidavit, I am going to find probable cause at this time. Whether more information will come to light at a later date, we'll see what happens with that following today's hearing.
Thank you, Judge.
All right. Thank you. Okay. We will go over to our hearing docket now. Going to the felony docket, on page 2, Dontavis Bryant. This is a 30-day motion, I believe.
Yes, Judge.
Which facility is Mr. Bryant
Judge,
at?
he's at Paul Ryan. We're going to waive his presence.
Okay,
And your information has been filed.
has been filed, okay. All right, then the motion will be denied, and Mr. Bryant will go before his division judge for an arraignment. Going to page 3 of the felony docket, William Steiner.
North Broward?
Thank you. Good afternoon, Mr. Steiner.
Good afternoon.
See, Mr. Steiner's here on a second look. His bond is currently set at $1,500, is that correct?
Yes, Your Honor. Judge Benson raised his bonds on both charges, actually, from $750 on the felony theft to $1,000, and from no bond attached to the resisting without violence to $500. I can tell you one thing that stands out to me on his booking sheet and PC affidavit is that both list a Jacksonville address, now different locations in Jacksonville, but both Jacksonville addresses.
I've never missed no court days or never not showed up.
And actually, I was going to ask Mr. Linder, can you check and see if that holds up?
Nancy, if you have anything, but
I was out on
while I'm
bond here
checking,
before.
Mr. Steiner, thank you.
Yes, sir.
while I'm
Yes, sir.
checking, does he in fact reside in Jacksonville?
Judge, he's advising me that he lives here in South Florida for about a year. He's been at the same address for about 8 months. He works at a fiberglass shop. He's been working there for about 7 months. He does have a daughter, an adult daughter who lives here in South Florida. He cannot afford to post the bond as set, and he is telling me he has never missed a court date. So we would, if that's true, if that holds up, Judge, we would think he might be a good candidate for a pretrial release, considering these are both nonviolent charges.
One thing I see as far as Broward is the one time he had a case and he bonded out, he had to be taken into custody no bond because he picked up a new law offense and violated his bond conditions.
When was that?
That was 2017. I'm sorry, Nancy, you have something?
Priors in Jacksonville?
Yes, I've been living here for
What-
basically.
what-
Easy,
Mr.
Mr.
Steiner,
Steiner.
just one moment, okay?
Oh,
Let me.
I'm sorry.
That's all right. Let me just hear from pretrial.
Traffic and stolen property in 2006. He was found guilty of those charges. 2004 burglary from the registration conviction. 2005.
And I would note in this case, the resistance without violence is because he fled from law enforcement. So it's another red flag about his willingness to show back up in court.
There's a difference, I think, from willingness to be arrested to willingness to appear in court once he is arrested. And again, I didn't hear anybody say anything about him missing a court date. I think he's a good candidate for pretrial judge if the court's willing to take a chance on him.
Your Honor, just so you know, when I check failures to appear, I'm checking, frankly, BSO pics to see when people have been arrested on capiases. Now, I don't know what pretrial has. I don't have access necessarily to other counties' information when they fail to appear in court or don't fail to appear in court, but that's kind of the whole point, is that, again, really, from what I can tell, Mr. Steiner has really no ties to this community.
I've been here off and on for 6 years.
See, and what Mr. Miller stated, I believe, was 8 months.
Said he's been at the same address for 8 months, that he's been here for about a year. That's what I was told, and that's what I reported to the court.
Yeah, no,
I've never not missed no Florida, Jacksonville court. Never, ever. I have a numerous record. I never not missed court.
Okay.
and again, you know, showing up in court is part of the equation. Not committing new law offenses is also part of the equation.
Sir.
I wasn't speaking, sir.
But if I don't get out, I lose my job and everything else, so I'm trying to get out, sir.
Mr. Steiner, where are you living presently?
It was a halfway house, but I'm probably no longer there because I've been in here. You have to be there every day. It was a halfway house.
Which one is it, Mr. Steiner?
Primary purpose, my stuff's still located there.
Is there any reason they wouldn't let you back in?
Most likely because I'm not there. Once you're not there for 20, you don't show up, they kick you out.
Well, that's,
Bottom line.
if you don't show up voluntarily, it's not,
That's it.
you're failing to show up is not voluntarily. I'm pretty sure they'll let you back in, won't they?
I haven't tried, haven't checked. I mean, I would like to get back in because I need to be in there.
Well, I tell you what, I would be willing to do, which we've done this a couple of times over the last couple of weeks. I would be willing to release him to pretrial pending their verification of his address. If they are unable to verify the address, then the bonds will remain in place. Okay?
So they're going to check and see if you're eligible to go back to primary purpose. If they'll let you back in, then you'll be able to you'll be released to go there, and you'll have to live there until further order of the court. If not, we're going to have to sort out your bond in division.
Okay. And how do I find this out? If it's a yes or no?
I'm sorry, what was that, Mr. Steiner?
How will I find out if it's approved or not approved?
Pretrial will contact you.
Yes.
Okay.
Okay.
To primary purpose for pretrial.
Primary purpose. That's off of Davie Boulevard or Davie, I'm sorry, Davie and 441, I guess.
Okay. All right. Thank you, Mr. Steiner.
Thank you.
And thank you, Your Honor.
Thank you. Next will be Christian Carasquillo.
He's at Conte, Your Honor.
Okay, thank you.
Good afternoon, Your Honor.
Good afternoon, Mr. Carasquillo. You are here on a second look hearing today. Let's see, his bond is currently set at $15,000. Is that correct?
It is correct, Your Honor, and Judge Benson, and I would ask that this go to his division. You know, Judge Benson had his first appearance, and she decided, based on everything she was told, that it was appropriate and necessary to raise his bonds from $1,000 account to $5,000 account. I reviewed his history, and I can tell you, he was released from state prison January 1st of 2019. This was after being sentenced to a year and 3 months state prison out of Miami-Dade for aggravated battery, burglary with assault, and strong-arm robbery. He has priors for burglary of an occupied dwelling out of Dade, robbery by sudden snatching out of Dade, strong-arm robbery out of Dade, possession of cocaine with intent, possession of cocaine with intent, aggravated battery, and strong-arm robbery.
Judge, I would ask the court to reconsider the bonds. I understand that Judge Benson may have had her reasons, but part of the reason we have the second look docket is it provides a check and balance on the system to make sure that everybody's treated fairly. We're dealing with two simple possessions. I looked at the probable cause affidavit. I didn't see anything that stood out to me as particularly egregious. He's telling me he's a lifetime resident of South Florida. Aside from his stint in jail, he's been at the same address for the past 5 years. He does have a job, A1 pressure cleaning. He's had that job prior to his incarceration and since his release. He's a graduate of American Academy and online high school. He does have family in South Florida. He can afford the standard bond if the court would return it to $1,000 per count. And so that is essentially what we're asking the court to put the bonds back at 1,000, and ROR on counts 3 and 4.
Your Honor, it's not unreasonable if a judge has a concern regarding a defendant that has a substantial history involving violence. And it's not inappropriate for that judge to have a concern for the safety of the community, even if the charges before that judge are not violent in nature. There's no reason to believe, Your Honor, that Judge Benson wasn't advised already of his ties to the community, his financial resources. I understand the concern about checks and balances, but if there isn't anything inherently unreasonable about the bonds that were set, I don't know that it's a necessary check on those bonds that were increased.
What was the most recent prior that you advised me of, Mr. Linder?
One moment, Judge.
I think the other priors were from Miami.
He's had other priors, but they're dated.
Okay.
This would be his first arrest since he got out of prison approximately a year ago.
I mean, obviously I wasn't here and neither were any of the rest of us for weekend first appearances, so I'm not exactly sure what was said during that time, but based on the information that's being given to me, I'm going to reduce his bonds to the standard bonds. That would be $1,000 each on counts 1, 2, and 3.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome, sir. All right. Okay, next will be Jimmy Morrell.
And he already bonded, Judge.
Okay. And I believe that brings us to the end of our first appearance docket for this afternoon. So I'll see everyone back here tomorrow.
Thank you, Judge. Have a good evening.
You too.